Hello, fellow lawyers. Today I am diving into a crucial topic for anyone dealing with Pagri tenants in Maharashtra, Section 56I of the Maharashtra Rent Control Act 1999. Let's clarify some common misconceptions. First up, let's tackle the misconception about Section 56I not applying in eviction suits. The Act states clearly that if a landlord requires possession of premises held by a protected tenant under Pagri, they must pay compensation equivalent to the market value of the tenant's interest. This provision does not exclude eviction suits. It's applicable whenever the landlord seeks possession, irrespective of how that possession is sought. Imagine if eviction suits were excluded. That would defeat the protective intent of Section 56I and enable landlords to avoid their obligation to compensate tenants simply by filing an eviction suit. This contradicts the tenant-friendly objectives of the Act. Courts have consistently emphasized that landlords cannot evade statutory obligations to compensate tenants by procedural tactics like filing suits. The Maharashtra Rent Control Act prioritizes tenant protection over landlord convenience. Now, let's address the argument that Section 56I applies only in cases of voluntary surrender. While the section does apply in cases of voluntary surrender of tenancy rights, it also applies to landlord-initiated actions, like eviction suits. When a landlord files an eviction suit, they are effectively seeking possession, triggering the compensation obligation under Section 56I. Precedents indicate that even if the tenant surrenders possession under compulsion, the compensation requirement under Section 56I remains enforceable. The wording of Section 56I does not limit its scope to voluntary surrender. Instead, it mandates compensation whenever possession is transferred from the tenant to the landlord, whether voluntarily or under legal compulsion. So, what are the practical implications for Pagri tenants? Firstly, they must assert their statutory right under Section 56I if the landlord demands possession, whether through negotiation, eviction suit, or court orders. Secondly, if the landlord attempts to evade paying compensation by filing an eviction suit, the tenant can argue in court that the suit cannot proceed without adhering to Section 56I. Courts may stay or dismiss eviction suits if landlords fail to comply with compensation obligations. Lastly, case law often reinforces that protective provisions for tenants cannot be bypassed by mere procedural strategies of landlords. Courts have interpreted tenant-friendly statutes broadly to ensure fair compensation. In conclusion, Section 56I applies whenever possession is sought, including eviction suits. Tenants must assert their right to compensation based on market value, as this provision is a legal safeguard to prevent exploitation. The interpretation that it applies only to voluntary surrender is legally flawed and goes against the intent of the law. Thanks for tuning in, and keep fighting the good fight.